Hi, this is Debbie Champion here for Lawyer versus Lawyer with Gary Berger.
Hey,
Hi,
Debbie.
Gary. How are you?
I'm great. How are you?
Good. I am happy to see you.
You too.
What good ideas do we have today?
Well, today we talked very briefly about, you've been telling me stories about getting ready for trial, and now trials are coming, and you tried one a couple of weeks ago, and I'm doing a lot of processes now, getting ready for trial. I'm doing a lot of depos and stuff. So I thought maybe, and actually, honestly, I just in getting some lawyers with my office ready for trial, I've made people start writing down what our trial process is.
Oh, that's fantastic.
So can we talk about litigation and trial process
Yeah, that's
today?
fantastic. You have a lot of trials coming up this year, right?
I do.
Me too. I feel like we're trying 2021. I mean, 2020. 21 and 22 all in the same year.
It's crazy. The schedules are crazy.
Yeah.
But judges are getting it and trying to move them.
Yeah. Have you noticed if the jurors are the same or do they seem different?
I think they're there for a reason, I mean, I think that we've done a couple now, they all seem attentive. I think things are going a little quicker, maybe more effective. I hate wasting time.
Yeah.
And I hope that now maybe that'll not always be the case, and I don't have a big sample size to look at, but that's what I thought. What do you think about the jurors?
I haven't seen much difference.
Yeah?
I was worried about it, but I haven't seen much difference.
Huh. You think because people are kind of done with this
I do. I think
pandemic?
people are ready to move on.
Yeah.
Who knows? I mean, I've only tried things in St. Louis County. I'll be in the city soon, so I'll let you know what I think, but I haven't seen a big difference in attitudes.
Debbie, tell me about your process what's your process to organize yourself and get things done for litigation and trial?
Okay, so I guess I'd start kind of at the end and work backwards, but I have a process that we use for every trial, no matter how big or how little, that some of my associates don't like. If they're trying a case, they do a different process because they like trial notebooks. I do not like notebooks. That does not work for me. I don't like the clicking. I don't like opening and closing.
You mean the 3-ring binder?
Yes.
Okay.
It drives me crazy. And the other thing is, apparently I have small hands. And so I
have small ears.
Do you?
I do.
So you probably don't like, what do you call them?
Earbuds?
Earbuds.
I do earbuds because I also am I don't hear that right. And I don't hear my daughters. And so everybody thinks I'm ignoring them in my house. So I got to get hearing aids. But anyway, sorry, go ahead.
They're always too big for my ears. So my hands, when I go to trial, I only want 3.5 width red wells, not 5.5. I can't carry the 5.5. I mean, it's crazy. I want my exhibits to look in a certain way with certain things in the file. I mean, I could go into detail on that, but I won't. But you have to have a process to make yourself comfortable about what you're doing. So I follow the same process every time, and that is I use a certain size red well with the exhibits in it. I mark. Well, this is how I get ready. I say to the associates, bring me everything in the file, every piece of paper, put it on my desk. I then go through from start to finish every single paper. I separate things I want versus things that are duplicative or things are the trash that I don't need. Things I'm not going to need. For example, when do I ever need a policy of insurance at the trial? Never.
Do you do this or do you have a staff person do it?
Okay. I will not go into trial without touching every piece of paper in that file. So separate that. But, that may take me, depending on how big the file is, it may take me an hour to 3. It's not a long process. So then I got my good stuff versus my bad stuff. Anything that may be relevant to that case, I mark as an exhibit, whether or not I'm going to use it. Only because that helps me organize my file. I love to do it in chronological order. I never do it right in chronological order. But I have all depots marked, I have all exhibits marked, I have all medical records, medical bills, anything you would need or I would need. If I have it in the file, it's marked as an exhibit. Now, that is a weird process that nobody else does, and I wouldn't even really recommend it for you, but...
Why are we talking about it then?
Here's why. Because if you do...
this is good.
If you do
everybody's got to do a little bit of process like that,
I think you have to have a process.
Sorry, go ahead.
You don't know where things are.
Yeah.
I mean, I will tell you, there's not a case that I go into where if somebody can't find something, I can't reach my hand out and pull it exactly out of exactly where it is. I know where every piece of paper is in my file.
That's admirable.
And so it's a weird process, but what at least, the worst part of it is, I may be conducting a deposition with John Smith, and I may be using these depositions. He's the first witness. I might be using Exhibit B, Exhibit P, Exhibit QQ, Exhibit RRR, Exhibit T. So they make no sense. It doesn't matter.
You were going to say, though, I interrupted you, though.
Purposes.
You were going on.
I think I was just saying this is the weird thing. That ends when I do that, when I mark so many exhibits and I know I'm not going to use half of them, you don't use them. You have to be willing not to use them. You have to not worry about that. And you have to not worry about the numerical or letter, order of your exhibits. It's just an identifier. It's no different than using red and blue and green and yellow and black. You have to realize it's just a number or it's just a letter, and it does not matter if they're in order. I don't care. And once you get past that, then your entire file is organized. And then I have what they call Debbie's file. And in my file, I have color-coded folders. So again, I know exactly what color is where. I have an appeal file. My appeal file is empty at the beginning of the trial. And every time there's an issue I lose or that might be appealable, I make a note of it, stick it in my appeal file. So that at the end of the case, all my issues on an appeal issue, are in the red file in the back of the folder. Motions in limine are yellow. My voir dire, my opening, and my closing are all purple. That helps me know where things are. So I do processes through color and inclusion. Other people maybe have a process. You probably have a process that's much more chronologically or otherwise logically organized, but this one works for me.
That's great. How
about you?
So do you have a team of paralegals and or lawyers that are trained to trial prep for you?
I have a memo telling them what to do. And so my secretaries both know, and I don't have a paralegal right now. So the associate is in charge of that trial prep. And that's not really true. That associate is in charge of that trial organization once I have the exhibits identified. But I do my own crosses. I do my own directs. I usually do all those myself.
I do those myself too.
Yeah. You can't learn the file otherwise.
Right. Well, that doesn't seem that crazy. I mean, I do. So my exhibits, a lot. So when I'm working the case, I will try to start with 1, 2, 3, and then I will use the same exhibit sequence through litigation. I'm in my 5th depo. I start with 34, and I try to keep a sequential long exhibit list to the 40s, 50s, 60s, and then I walk in. And I can have exhibit 1 is this, and sometimes I get it wrong. Although sometimes, then when I go into trial, sometimes you pick stuff that isn't relevant, and then I'll jettison that and I'll replace it with something key. Because when I'm putting on the way I look at a trial and the way I prep it is the first thing I do is my voir dire, because that's the first thing I do, and then I do my opening, and then sometimes I don't have my closing done when I start trial. So I have that closing. I'm finishing that. But I know the first thing I got to get done because I'm busy is I got to get voir dire done. So that's my first.
Right.
And then I open.
That's what I do too.
And the third thing I do is direct to my client.
Right.
And then then my direct with my client is going to have my client and then my exhibits. And I know what exhibits I'm using for my client, and I have the original and 3 copies behind it. I don't like to have I hate using an exhibit with someone. All right, now we need to go 4 other places for copies of the same exhibit. No, I want them collated. I want exhibit 1 and 3 copies of it. So I can hand one to opposing counsel, judge, anybody else. And the witness wants one and I want one.
Right. I do one thing different than that, though, Gary. I have the first exhibit. That's the one that's marked. And then the 3 copies. And then I switch up number 1 and number 2. Here's why. I always write on the top one.
I do too.
So they know, don't put the ones you can't write on top.
My exhibits have. I put my initials and we highlight them at the top, and I use number 2.
Me too. And I put them on number 1 because I just went.
You're going to take the first one always?
Yeah.
All right, that's funny. I should do that.
It's easier.
And then mine, because I know mine, I got to take, because that's what I'll do. That look, I mean, I prep a lot and I'm ready to go, but I'm also the night before I'm getting my crosses ready, and I'm so I have my copy and I'm going through the exhibits and I'm highlighting and I'm writing questions in the margin of those exhibits.
Absolutely right.
Because then I can have that exhibit in front of me, and I don't need a handed notes. I do a lot of my trials without notes. And I just have it on an exhibit, and I know what I'm asking, and I jump from here and here and here, and I can, and that it works for me.
That's excellent. But see, yours is so much better because you're using only the relevant exhibits, and when you finish, you're going to have most of those exhibits in evidence, and they're all going to sound like 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. I'm going to have 160 exhibits and use 5 of them.
Well, here's the other thing I do. I hear you. Here's the other thing, though. I have a team of, like, my paralegal is always, you're most of the time with me in trials, and she tells a story. I tried a big case, and I kept telling her, I can do it without you. I can't do it without you. She goes, I was laughing so hard because Wednesday morning, Casey, you're going to be here tonight. I need you in a hotel room. This is what you're doing. I need someone who, because she knows how to do the exhibit list. She knows how to find the stuff. She knows where stuff is. So that when I have something that's not, the difference in our systems is that you don't want to get caught having the one document you need when you're getting up to cross and no one knows where it is and you can't find it. And that keeps you up at night. I get that big time. I've been there. What I do is I know enough of the file, and so does my paralegal. So I say, I'll turn to her and I'll say, remember that one set of documents that I put on your desk here that we ended up thinking we didn't need, and we put in the one folder in the back of stuff? Remember, it's about 2/3 of the way in. There's a tab in the bottom right corner, and I remember seeing it, and she'll find it, and then I'll have it by the time I get to it in 3 minutes later. So
that is great. That's somebody great to have. You all speak the same language anyway.
She does. She knows. So that's kind of my process for that. What is your process for... What's your process for? You could pick. I got 2 questions. I was going to ask, what's your process to getting ready for voir dire and keeping people straight? And then what's your process? Let's say the 3 weeks going into trial, the time when it's the real crunch time. You got to get your Depo designations done. You got to cut your exhibit this. You got to make your demonstratives. You got to cut your Depos. You got to decide what to do. You got to what theory of the case. How you prepping your people, all that stuff. How do you do that?
First thing we do,
process-wise,
we index every Depo. Do you do that?
I index, no.
The reason I index every Depo is because when I get to my cross-examinations and even my directs, I have, I start off asking them questions from their Depo, and then I have the deposition page and line behind that question.
I have that too.
So that way I have my index.
I do a lot of them.
You do? Okay, so not
the
every
main
one of them.
ones
Yeah,
that I need to do a good cross, like the driver or the corporate rep or this stuff. Yeah,
I probably do that too. I skip things I don't need. But if I'm going to have to cross somebody, I definitely am going to index their depositions because I do all of that before I think about my opening. Because
that's smart.
I don't know what I'm going to say in my opening till I know what the facts are.
Right, you're right. You got to remind yourself.
But and I also go early with all the doctors because the doctors help me decide what I'm asking the plaintiff.
Yeah.
And so that helps. And the police officers.
When you say I go early with the doctors, what does that mean?
Indexing them and identifying what I'm going to read from them or what I'm going to mark.
Do you do medical summaries?
We have a medical chronology.
I'm big on medical summary.
Yeah, we do a medical chronology day to day on most medical cases. We'll do a chronology, what day it was, what were the complaints, who was the doctor, what they do for them, what they say. And so I have this medical chronology, which really helps me see when complaints stopped or whether, when there was a 1.5 year gap so I'll do that.
I don't like that because then I lose. I'm not good at looking at a bunch of stuff and picking out I'm like, where is the surgery? I can't find the damn surgery in this chronology. In the grocery store, if I'm in the bacon aisle, I got to find one kind of thing, I panic. I cannot find one thing in a whole shelf thing.
Yeah.
So I laugh at myself. I'm old enough to laugh at myself because I know that. And I'm the same for trial. If I got too much stuff everywhere, I'm like, I want to talk about this with this witness.
You are a good big picture guy, though. You know
sometimes.
what you're looking to get, and that's what you go get.
Yeah, no, actually, I've learned in this business, I try to be big picture because I don't want to waste my time.
Yeah. And it's too easy to get in the weeds.
How do you make sure you're getting your exhibit? Well, you talked about exhibits. What about like getting Depo designations and motions in limine and all that done? How do you do that?
Depo designations continue in every case to be a pain in the rear because if you do yours, the other side doesn't do theirs.
Right.
And that's really frustrating. And so I do mine. I usually have them ready to go, but I can't tell you how many times trial starts Monday and I'm getting their deposition designations on Sunday.
That frustrates you.
Yeah, it doesn't make any sense to me because I had to start with the doctor and now you're looking at your doctor for the first time, or is it a game we're playing so that maybe I can't object to all your designations if there's something to object to. Although in doctor's designations, you know what I've objected to already. I
don't want to have to be editing depots during trial. I want to have that done. So I really like to get my designations done. I want to know what the doctor's going to say. Because what if I can't prove my case? What if you objected to my causation question and I didn't call you up on it? I need to have a motion limine. I need to get a hearing. I need to get a ruling on that because what if I need a continuance? What if I need to do something else? Always like...
Say that again because that's an excellent point people need to hear about.
Here's another thing. When I have exhibits, how are you getting that in? How is that coming into evidence? Is someone testifying to that? Is that a picture? How does that come in? Do you have the business record done? What about the hearsay within the hearsay? You got to be ready. You were talking in another podcast about technology and technology breakdowns. I mean, I have a black thick pen in every trial bag because I need to go redact insurance out of a medical bill, or some judge decided hearsay within hearsay within hearsay in a medical record. They're not like me to. I got to mark shit out because I got to get it in front of a jury.
Right.
I want to know how everything's coming in evidence. I need to get diagnosis, I need to get diagnosis, causation, I need to get prognosis, chronic, disability, and I get it to RDMCA, reasonable medical certainty, and I need to establish that, and the doctors need to say that.
And if there are objections, you got to get it early enough you know what you need to do with it.
Yeah, I need to do it because... and I usually ask, if there's a good form objection, I'll ask you during the depo, what's my form problem? Tell me and we'll cure it and stuff. But I don't want to because it really helps the other side because the other side can sandbag you. You didn't take up my objections. You're playing it. And they're like, I got an objection there, and you're breaking and you're like, they're like, It wrecks you. It wrecks you. It kills your flow. So I want to get my motions eliminated. I want to get my designations done. I want to have a pretrial. I want to rule on this stuff. And I have what I do is I sit down and I make a punch list for trial. So starting a month out, 2 months, I'm sitting down here and I'm having a meeting. I'm writing down, here's everything I need to do before trial. I literally still write down, I need to do my opening, I need to do my voir dire, and then we have it checked off, and then we have a file, and if I haven't done it yet, they're not bugging me about my closing, but they're bugging me about where's your voir dire. And then I have a form voir dire I do use, and I have ways that I like to do it, questions.
You have a great voir dire.
And then I have my little magic impeach when I get someone on the line, when I catch a fish or something, I need to close the door on so that the defense lawyer can't come up and say, hey, can you be fair and impartial? Sure, then they're in the case. So
you have a great impeachment line too.
Yeah, and then so basically making lists. So process-wise, I need to have lists. I need to have things checked off, done, and then a trial. I have a opening folder. I have a closing file. I have a voir dire. I have opening. I have closing. I have direct, and each of those is in a little separate manila file.
Yep, me too.
Or sometimes they're also in one big pad, and so I'll have my opening and my directs behind it.
What other folders do you have that people might not think about?
I have my do not use folder. stuff that I cannot use and show to that jury. I'll put in the insurance question. I'll put in healthcare benefits. I'll put in stuff I'm not supposed to do and not supposed to say.
Yeah. But you might need that stuff for some reason.
I write the word relax on the top of almost every opening and closing and direct of my clients.
I write slow down.
I write that too. And the thing that I do too is I have my list. One of my tricks is I get in the medical twice in a way, because I play the doctor's depots, but I take the medical records and I go through every page of the medical records and I highlight what I'm going to read to the jury, and I have a separate thing where you were talking about in a prior episode about not putting in medical bills. I make a big deal about it. This is formally into evidence. This is proof. This has been accepted. And I read the amounts to the jury in medical bills. I'm a little old. Doctor, this is a bill from Barnes Jewish Hospital bill. It's just $10,412. Now, sometimes there's stipulations that I want to bore the jury and that kind of, but then I will also read. I have a folder then I have a section in my trial of medical I'm reading to the jury. I give the defense lawyer the same highlighted version so that they follow with me, and I stand up page to page and I read it as a presentation of the medical records to the jury. I don't know if a lot of people do that. I don't know if that's
you would be shocked at how many people make a conclusory exhibit, give that to the doctor. The doctor's never seen the bills. The doctor hasn't seen anything other than this conclusory exhibit, which may or may not include irrelevant things on
That
there.
gives you so much fodder for cross.
You wouldn't believe how many times they might have pre-existing records in that bill. They're billing for pre-existing treatment almost every time. Or they're billing for post-accident treatment that's not related. Her gynecological exam is in there. What are you doing? It's just sloppy. But I think the way you're doing it is the way it should be done. You're reading the bills. The jury knows the numbers. The jury knows you didn't make up the numbers because you're reading them from there. You're not just throwing up some conclusory number. I think that's the way to do it.
Same question back to you. What do you have in your file folder that people may not know about?
I have a folder that I take every time that is pleadings at issue. So I always have my petition, my answer, any counterclaims, any amended petitions, whatever. I have all of that. So when we're dealing with the instructions, I have it right at my fingertips as to what was pled to begin with and what my defenses were, because sometimes you forget what your dang defenses are. And then I have a case list for trial, which is a case list of stuff that comes up all the time at trial. Like the cases that say you can't get police.
Oh, when you say legal authority cases on various evidentiary issues.
Yes.
You see
that's
over
probably
and over
gold.
and over again. Yeah, isn't that gold? Is that private?
No, I'm happy to share it. You wouldn't care as much about those things because it's mostly defense issues,
right.
Like contributing circumstances can't come in, that sort of thing. And we have judges that are younger and younger who haven't tried these cases, and they don't know that off the top of their head. A case that says if you don't bring up the damages or the number that you're asking
first
for,
half of closing,
you can't do it later. People don't know that now.
I tried a case in front of one of my first cases I tried. I was in the city and I kind of didn't do that, and the other side brought it up, but I knew the judge, and she said, "Oh, I think he mentioned it, but I kind of didn't."
Yeah.
I think it was a defense verdict on that. So I think I lost that one. So there was no harm, no foul.
Oh, that stinks.
There was a backdrop. I lost the case. All right. Well, that's great. So you have that. You want to know what I do? Here's something I do. In voir dire, I have the statute on jury selection in every voir dire folder, because every time I walk up, the statute in Missouri is great. It's stronger than you think for striking people with cause.
I gotta get that.
I file a jury selection memorandum, because one of my pet peeves is when I do a great job getting someone to say they can't be fair and impartial and they got views on this issue, blah, blah, blah. And the other side comes up and says, "Okay, are you going to be fair? Yep. Can you follow the judge's instructions? Yep." And they sit down and the judge thinks that's good enough.
Yeah.
And so there's a lot of cases that say you can't rehabilitate with direct question with leading questions. There's cases that say, and then Missouri, it's an old statute. It's something like if you have any view of an issue at the case, you should not be on this jury. So I bring the statute up because the judge is never. I don't think I've ever had a judge read my brief that I file.
Yeah, they.
But if you just bring up, and I have this one, it's in the middle of the. It's in the middle of the. It's in the middle of the thing. I have one that I bring the statute and there's a line in the middle I highlight and I just show it to the judge, and it's hard to argue with that.
That's perfect. I've been seeing people follow a lot of those briefs on voir dire, so I'm glad to hear why that started because.
Do you do that?
No.
All right, but that's But things like there's things that I forget like. Can you get in the property damage repair to show proof?
Right.
You can't do that.
You can now, but there was a time when you couldn't.
See, so, I need to. Yeah, some of that I need to blow that. I should have that. I should do a better job on.
I just have the cites. I don't have the cases with me. I just have the cites. And then the little rule of law, so you can get 3 or 4 pages in there and a lot of law in there, just in case you need it.
Yeah, at your fingertips. Yeah. That's great.
And then I have, and this is silly, but I can't tell you the number of times I've needed it. The telephone number and contact info for everybody I might possibly need. Witnesses, my client, if they don't show up.
Yeah. That's really smart. I can't tell you how many times I've said, where is that witness?
Exactly.
I don't know. They were supposed to be here.
Right.
I don't know. They're not here. It doesn't matter where they are. If they're not there and you're ready to go.
That's right.
And you've had to use that, I bet.
All the time.
All the time. Mm-hmm. Have you had to drive people and go get them and bring them to trial?
Oh, yeah. You do that.
Yeah.
I haven't done that in a long time. I make other people do it now, but I have done it before.
Oh, I've had people. I haven't done it because I'm trying it, but I've had it.
Isn't that funny?
Oh yeah. Oh, I had a guy. I couldn't put in a statement in a dog bite case because somebody had sent out an investigator. It wasn't my investigator, and I had a law clerk, and he was watching this, and I brought up, and it was at a break, and I couldn't get this statement in because at whatever level of hearsay. So I said, I go to my law clerk. I go, here's $100. Go get this guy right now. Give him a witness fee of $100
right.
and bring him back here. And if you get him here by 2:00, here's another $100 for you if you're able to do it. So I incentivized him.
Perfect.
And after lunch, that guy showed up on the stand and took the stand. And the other side was shocked that I found this guy. But a $100 bill gets people. So he came in. I said, did I pay you a witness fee? Yes, you did. And then my law clerk, the law student, was back in the gallery with a $100 bill in his pocket, and we won. We got a great verdict, and it was totally worth it.
I love that. That is so fun.
Tell me, have you done anything like that?
No, I'll tell you what it made me think of, but this is kind of a bad part of that. When I was a brand new associate, very young, we got a telephone call during trial that my boss, Jeff Thompson at the time, was up in federal court trying this case, and the expert witness was not going to show. So this is he was the best person in the world to learn from because
Jeff Thompson. What firm? Evans and Dixon.
And he was completely unflappable. I mean, you could not get him upset. And so I had to go tell him, your expert witness is in Hawaii. He's not coming. And so I show up and I get him to come over there. And I said, Jeff, I got bad news. Your expert witness is not coming. He said, okay, where do you want to go to lunch? I said, no, you don't understand. I'm telling you, your witness is not going to be here. He said, that's okay. I'll read his report. And so he went over to the other guy and he said, hey, my guy's not coming in. You care if I read the report? No, that's fine. That's how cracks the law used to be.
That's how it used to be.
Yeah.
Exactly right.
So, but that's what your story made me think of, is
that's
on the
funny.
fly trying to figure out what you're going to do to deal with this issue or that issue.
Yeah. I got to remind myself to be more unflappable because you know what? It's a big deal in that moment, but you know what? It ain't a big deal.
And the problem
most of the time
with letting yourself get all riled up, and I get all riled up, so I know the problem.
Me too. I don't know what you're talking about.
the problem is most of the things don't matter.
They don't.
The jury already knows. I mean, and you just, you start tasting blood, and you just commit error because you push it too far or you fight too hard. I don't know. That's the best lesson.
Yeah, I was trying a case. You're right. I was trying a case in front of Judge Kramer in Jefferson County one time, and I wanted to use this instruction 2.7.
Yeah, 2.07.
With the withdrawal one on
the
insurance.
Yeah.
Yeah.
Yep.
And he goes, and the other side was complaining. No, he can't use it. He can't use it. And he goes, and he looked at the defense lawyer. He goes, do you know where that instruction came from? And they go, where? He goes, I wrote it. And I gave it to the committee. Because do you think there's any case that's ever tried in a car crash case where the entire jury doesn't know you have you can't. You have a minimum coverage law. And if you don't have insurance, you're in jail. Everybody in that veneer panel knows the defendant has car insurance. And I've never done a voir dire in a car crash case where it didn't come up. It always comes up. It doesn't sometimes. It always, because everybody's been in a wreck. Have you been in a car wreck? Yes. What happened? I turned in my insurance.
Right.
It comes up every time.
It does. That's hilarious.
So
he let.
Oh, absolutely, he did. Yeah.
So I remember Judge Kramer. The worst thing that ever happened to me in front of him is that he struck one of my experts. And I thought, oh, this jury's never going to understand how this accident happened. And I had an expert coming in to explain the laws of physics. And I really needed him. And he looked at me and he said, how stupid do you think these jurors are? And I said, well, I didn't get it. And he said something like, well, our jurors in Jefferson County are not as dumb as you. It was hysterical. We all laughed. And sure enough, he was right. They got it.
And you won the case, I bet.
But I remember being, just devastated. And I was going to lose this case so big. And it just didn't matter.
Yeah.
People, jurors are way smarter than we give them credit for.
Yeah.
That is so
that's funny. All right. Well, then we've done another episode. Thanks so much, Debbie. I appreciate it.
Good to see you.
All right. We'll see you at the next episode of Lawyer v. Lawyer.